Welcome to U.S. Law Shield News Update. I'm Sam Malone in Houston. Lots of stories to cover today. Man, it's never a dull day. Program attorney, independent program attorney, Michelle Byington joining us via Skype on the screen. Michelle, how are you?
I'm well. How are you, Sam?
Fantastic. All right. Miss B, there's a lot of stories we have to get to that concern us pro-Second Amendment folks that you can help us walk through and explain as an independent program attorney with U.S. Law Shield. The first involves the governor of our state in the great state of Texas, Greg Abbott. I'll read it. Leading a coalition in filing an amicus brief about California's restrictions on concealed carry permits. You mean that California doesn't like it, that I have a CHL from Texas?
I know. Aren't you shocked to hear that sort of information? I know. Mind-blowing. So this is really fantastic on our governor's part. He filed an amicus brief, which basically is a friend of the court brief, is all that is. It has no sort of bearing on the court. All it is his persuasive authority. So he did, in fact, file one of these and had some pretty great language in that brief that said, basically, there is no other amendment other than the Second Amendment that gets assaulted left and right. If this were a First Amendment issue, we wouldn't even be here talking about this. But because it's a Second Amendment, people automatically want to do what they can to threaten that amendment and your gun rights. And so he went ahead and filed this brief, and hopefully the California court will take a hard, good look at it. Because, if we were to travel to California, we can't bring our guns because, number one, our license to carry here in Texas is not recognized there in California. And if your gun is capable of holding more than 15 rounds, it's considered an assault rifle or an assault weapon, in California. So we're kind of left defenseless.
You know, and here's what's crazy. I could see if you had maybe, and I'm not a lawyer and I don't play it on TV, but I could see maybe if you had a gun permit from some third world country we never heard of, and you say, hey, I want to have those rights recognized here in America, we go, I'm not really sure. But this is Texas to California. Aren't we all part of that same union? And if I have a concealed handgun license or license to carry in Texas, why wouldn't one of our fellow brethren states recognize that?
Well, this is your common sense coming into play, Sam, and common sense and the law don't go hand in hand, so you need to cut that out, number one.
I'll never do it again. I'm so sorry.
And number two, it's just there's no logic behind it whatsoever. I mean, there is states' rights, and we all agree with states' rights. However, this is just simply following the Constitution. How hard is that?
Well, Michelle Byington, independent program attorney, U.S. Law Shield with us. And one more comment from the dork with the mustache. But why is it that my driver's license from Texas is recognized in California, but my license to carry from Texas is not recognized in California? There's nothing in the Constitution about driving.
Oh, gosh, there you go again with your common sense. I told you to cut that out.
I'm sorry.
And on top of that, it is so much more difficult to get a Texas license to carry than it is to get a driver's license. Any idiot on the street can get a driver's license, as referenced by Houston traffic as I drove into work this morning.
That's right.
But the eligibility requirements to get a Texas license to carry are so much more strenuous. Right. I don't know.
Exactly. All right, number two, Michelle Byington, independent program attorney, U.S. Law Shield with U.S. Law Shield News. On the White House website at petitions.whitehouse.gov, there's a petition for repealing the National Firearms Act of 1934. They've got they passed 250,000 signatures. Walk us through this first of all. What is the NFA, and why should we want to sign this petition to repeal it?
Okay, so the National Firearms Act, of course, was passed a very, very long time ago in response to gang violence in the 1930s. So when you think about, your gang movies, your 1920s, 1930s gang movies, they've got suppressors, they've got short-barreled shotguns they're using, they've got machine guns they're using. So the National Firearms Act was passed to make it more difficult for gangsters to get their hands on these sorts of weapons. And that law has stayed in effect up until today. And of course, as we see now, machine guns are not used to hold up banks. I'm not going to say no one, because I'm sure someone may, but some people Very few people use suppressors to hold up banks, if any. I haven't heard any use a suppressor in furtherance of a crime.
Right, right.
We don't see bad guys using short-barreled rifles to commit crimes. And so this law is somewhat archaic, and this petition has been circulated to basically bring that to light, that look, there is no reason why these sorts of weapons should be regulated. So in order to lawfully possess one of these weapons, a machine gun, short barrel firearm, a suppressor, which we've talked about before, you must get federal approval, which takes about 8 months for the feds to approve you.
Wow.
And plus you have to pay a $200 tax stamp to the feds in order to possess one of these weapons. So again, the law is archaic. We don't see a big uptick in crime with criminals using these types of weapons. So you would say, then what's the point in this law? So that's what that petition is about.
And finally, why do they need a tax stamp? Why, if I choose to buy a suppressor, maybe I want a machine gun. Who knows why, right? Why do I have to pay a $200, which is steep, a $200 tax stamp to the federal government? What's their action? What's their action on this deal?
Barrier of entry back in the 1930s. So $200 back in the 1930s is the equivalent of what, like $5,000 today? So it was a big barrier to entry then. Now $200 is nothing to shake a stick at by any means, but now $200 is not what it was back in the 1930s. But it's just another barrier to entry to lawfully possessing one of these weapons.
So bottom line, Michelle, let's pile on to petitions.whitehouse.gov and repeal the National Firearms Act of 1934. Done. You know, listen, when you visit, I sound a lot smarter. You know what I'm saying? So I appreciate you coming on and breaking all this down for, guys like me, LCD, lowest common denominator. Good job.
Anytime, Sam.
Independent program attorney with U.S. Law Shield. It's Michelle Byington. Thank you so much for joining us on U.S. Law Shield News. I'm Sam Malone. For more information, visit our website, uslawshield.com.